My lady,
So that you would
Assign
assign to
your two co-accused.
I've said, my lady, that in terms of reporting, I think it is very important to distinguish the reporting protocols. Like for the clerical officer, they have their distinct line of reporting. I don't assign them duty, but they are assigned official duties. Similarly,
So you are saying okay, repeat that.
I'm saying, my lady, that for the clerical officers, they have their distinct line of reporting, and they are headed by the head of human resource. And even the duties they are assigned, or the transfers and the deployments are done by the head of human resource. I would assign him official duties, official government duties. My lady, I would not assign them or assign any other person an illegal duty or task.
There was what's been commonly known now as the Nairobi trip, where you did Sharon and XYZ are said to have come to Nairobi. Do you recall recording a statement on the 21st of September 2018 in relation to that trip?
I did record a statement in relation
21st of September 2018.
And my lady, my response is that I recall I recorded a statement in relation to that trip.
What did you say in your statement back on 21st September 2018 in relation to that trip?
My lady, I said I had no knowledge about that trip.
Were you in Nairobi yourself, and what had you come?
My lady, I was in Nairobi and had come for the Council of Governors meeting.
And why is it that you did not have your staff with you, even your PA, and you're here on official duty?
My lady, the Council of Governors meeting is only meant for the governors. There is no provision, even up to now, for any governor to carry their staff when attending those meetings.
That is what you recorded in your statement on 21st September 2018.
That is true.
What is your evidence today in relation to that trip? Is it similar or is it anything?
It is similar, my lady. My position, what I recorded, and my position as at now is still the same. The staff do not attend those meetings.
So in short, you stand by your statement.
I do stand by my statement, my lady.
While still on statements, you first recorded a statement on the 11th of September 2018. Do you recall that?
I
Please
do.
confirm.
I do recall.
Do you still stand by your statement of the 11th September 2018?
My lady, I still stand with the statement that I recorded on the 11th of September.
Those are two statements.
2018.
Any other statement you ever recorded?
I only recorded two statements, my lady.
Now, you were asked about the reasons for terminating your relationship with Sharon, whether or not it was because she became pregnant, or whether or not you feared people knowing, or several other propositions were given to you yesterday by my learned colleague. Please clarify why you made the election to terminate the relationship.
My lady, I enumerated here a number of inconsistencies. That was primarily my reason for developing the cold feet and terminating the relationship. And I stated that that was around February, March of 2018. So it was as a result of the inconsistencies, and I give various examples here.
I'm happy with that. But let me just say as to the propositions. Because it was put to you very strongly that it could be because people had known about your relationship. As of February, March, people then knew about your relationship. It was no longer secret. And that's why you decided to terminate it. Would that be true as proposed?
My lady, that is not true. I did not terminate it as a result of people knowing, but because there are a lot of inconsistencies.
Had people known about your relationship at that time?
My lady...
Or was it an open secret as we call it?
No. My lady, I believe as at that time, people had not started knowing about it. Right. Those were early days. I don't think, my lady, people had started knowing about it. But now, after we had terminated the relationship, I think now people got to know about it.
How so? How is it that it became, you say it became really public or an open secret after terminating or not during the existence of the relationship?
I may not know exactly, but maybe I can only imagine that maybe by terminating the relationship, the late Sharon maybe was now talking more about it. That is just my imagination. I don't have a clear
That's fine. Let me delve in the second preposition that it's because you are uncomfortable with her being pregnant for you, and that's why you decided to terminate it. Were you uncomfortable about her being pregnant for you?
My lady, I stated here yesterday that my decision to terminate the relationship was not about the pregnancy, but primarily it was as a result of the inconsistency.
You've said that, but I'm asking a more direct question. How did you feel about her being pregnant for you?
I told her it was okay. Even for the first one, which she disowned, I told her kudos, the first one. Now for the second one, I also told her it was okay.
A prosecution view is that you were elected to kill her because she was carrying your child.
That is
So
not...
I want you to clarify how exactly you reacted to her pregnancy, even after terminating the relationships.
My lady, I explained here yesterday that even after terminating the relationship, I was still giving her money for her welfare. That means even for the welfare of the child that she was carrying for me. And that is the truth about the whole thing.
And that provision went off. You broke up in February, March. That provision for her welfare went until...
That provision went on until the time of her death. Around that time, I was still providing for her.
Really, there is also questioned during cross-examination evidence that you're providing for. What is your evidence that you're providing for?
My lady, my own testimony here, I stated that when we started, I was giving direct assistance. Later on, even through Mula, I was giving that assistance. And I believe that even if you check, yesterday I was being shown something by Wakili Awur here about the messages and the call logs. I even came across one.
Just make a difference you want to know.
Yeah, that document you showed me. I think it was showing me around page 20. My lady, there was Sharon herself was saying, "Oh, thank you. I've received the 100 Kenya shillings, the 100,000 you have sent to me in the columns here."
As I help you get that, let me just move on for better time. We'll come back to that. Yes, so you...
Through Mula.
Through Mula.
Yeah, that is true.
Speaking of evidence, what was the evidence of Mula in as far as in providing?
Confirmed.
As a prosecution witness, about your provisions and his findings.
My lady, the investigating officer also confirmed that I was giving assistance to Sharon.
As it were then, she hopefully safely delivered. What level of assistance or plans had you put in place? So just break down when you're saying assistance before pregnancy and hopefully if she lived and subsequently delivered. So just break that down.
My lady, initially, I wanted to assist her to grow a business, and I was giving that assistance. When we now broke up, I was still assisting.
said initially?
I was assisting her to grow her business. Yeah, but after we broke up, the level of the assistance now reduced just to the mere basics, the upkeep, the mere basic. But I had plans of settling her, including looking for land to build for her a house.
And what was your reasons for settling her, buying land? The intention was to buy land and build a house.
That was just to settle her because of the child she was carrying for me. We had started as friends, but now the inconsistencies. But we had agreed on the way forward generally that if she was carrying that child for me, I wanted to be a responsible person by assisting her, settled somewhere comfortably.
Very briefly, we've talked about assets before this settlement, before buying the land that was in plan of building the house. Any stopgap measure or temporary measure you have taken?
My lady, in the meantime, as we were waiting for that house to be constructed, she wanted to move out of her mother's house into a rental house somewhere in Homa Bay town.
Did you make provisions for that?
I did, my lady, make those provisions.
Medically, what good help did you provide?
That one I did, my lady,
How?
by giving her money to take health insurance.
And the everyday sustenance, would you provide and send her money for that?
I wouldn't say that I was giving her, or
Not giving her every day.
yeah, but what I was providing,
Yes.
I felt was adequate, to help her meet some basic needs.
The counsel for the victims estimated that even after breaking up, you would have spent 3.5, in excess of 3.5 million on her for those provisions, which you thought was very much on the higher side. What is your evidence? Or rather, what's your testimony?
My lady, this thing depends on what your imagination is or your expectation is. Sharon herself even wanted a more expensive house.
Forget about the house. He's saying that 3.5 million is in excess of that you are providing.
Yeah, my lady, I was comfortable. I was comfortable with spending that. Yeah. And
It was
at a
proposed to you
plan.
that was quite a lot of money. What was Sharon's feeling to what you are providing?
Eventually, she accepted. Initially, she felt that that was not good for her. But Muller convinced her to accept To me, it was a good proposal, which she eventually accepted. Initially, she wanted a house in Nairobi or Kisumu.
I'm happy. So let me move to the next link. Sorry, still on provision. What?
Found out that I was still giving those provisions, the financial provisions, even after we had broken up.
That is the investigative officer, the IOPW 42, Nicholas Olesena. What does he say?
Mr. Sarana, remember this is the examination.
In fact, that's what I was going to say, my lady, because we won't be able
It's
to.
no longer, it's not cross-examination.
Yes, my lady,
Remember the purpose for the examination.
correct, my lady. My lady, what I then only need to establish, because my learned colleague during this examination questioned whether or not there was evidence about two things, the provision and two, the open secret. So I am only referring to the evidence of the prosecution itself to show that there was evidence indeed that this was an open relationship. So that I am only referring him to the evidence of this being an open secret by the prosecution itself.
Because I thought you have already established that by the question, by the few questions that you have already asked.
I started off
why he did it.
because when they questioned whether or not there's evidence of the open relationship, I tackle it in two. I want to tackle it in two things. The first is his own evidence, and the second and the final one is the evidence of the prosecution itself. Just to dispel the notion created in, or rather the attempt in cross-examination to show, in the examination to show that there's no evidence. So I'm establishing his own evidence which he has given, and I am now referring this court.
And to refer to a document right now, which I cannot then cross-examine if needed, is limiting my ability.
I am happy if you settle just at reading it. The evidence of
I think that may not be permissible at this stage. But you can ask him questions that would clarify anything that was left in doubt during his examination.
okay. Mali, that's fine. Then I'll directly ask the questions without him reading. What did through the IO?
My lady, the IO stated that it was an open relationship, and even after terminating it, I was still giving assistance.
Now I'm still on open relationship. I finished on the provision.
The IO, my lady, confirmed that people knew about this thing. It was an open thing.
Let me be more specific about people knowing. Your staff or county officers, did he say anything about that?
I did.
Did
say
he?
it.
Olesena.
Yeah. The IO also mentioned that, the staff. He also mentioned the family knowing.
I'm moving in steps. I'm still at the...
The staff, yes.
How about your family knowing? What did he establish?
He also did establish that my family knew.
I want to be more specific. He specified particular members of your staff, of your family. Do you remember? And
I
even
do.
those he took statements from.
My lady, members of my family that the IO specified are my wife and my firstborn.
those are the ones he specifically mentioned. What did he say about them, or how did he establish that they knew?
My lady,
I'm not taking it a bit.
Mali, that's
I
fine.
think you're stretching it.
I'm happy. I think the rest are leave for submissions. Have you seen what you're making reference to?
yes, my lady, this was a message on the 17th of August 2018. It talks about, I got 100,000 shillings you sent to me. We'll arrange how to pay the house tomorrow.
I think that will be sufficient.
Yeah.
The date again?
The date is 17th August 2018.
Mali, that's exit 51A.
Can resume your seat.
The first accused will mention the two have testimony, evidence of the two persons in one other person. Having reviewed the evidence and the issues, we feel that the second witness will be reiterating what has been done. We may not be recording any part of it. Mr. Gada is present and Mr. Oronga is also. My two learned colleagues are asking me to donate the time to them, but time always belongs to the court, so we are taking it back to the court. We are most grateful.
All right. So in the course of the case for the first accused, you can address the court for the ability to proceed with it.
Thank you, Alex. They indicated that they needed 3 days. Prosecute their
a few instructions on part of the evidence given. Equally, my lady, we have not brought any witnesses this week, owing to the fact that we had hoped these 3 days would be utilized by the first accused. Simply, my lady, because
Maybe you could address us on whether the position is the same as we had indicated when we took directions for the defense.
my lady, tentatively, we'll bring about 4 witnesses. Tentatively, my lady, because we are still trying to procure one very crucial witness. My lady, I hope I've sufficiently answered that question.
Yes, you have.
Save that, my lady, I want to make an application that the prosecution furnishes us with the complete call data for the second accused. Data was from 2nd of August to, from I think 17th of August to 3rd of September. Only a fraction of that of those call records were produced, my lady. We would want to use those call records. They were never given to us.
My lady, the call data that we had to be presented to court, unless they have other call data that we are not able to
My lady, Mr. Olesena had indicated when he testified for about a month, but only for a few days. But be it as it may, as the prosecution has indicated that the ones they gave us is what they...
Produce to the defense what they are using or what they are lying in their case, which they have already.
That evidence will come out through the testimony of the second accused. I'm ready. We so that now we have sufficient time to internalize what the evidence given by the first accused, and then we'll be ready to proceed on those dates. The 3 will be very short. It will even be tackled in a day. So tentatively we'll use the first 2 days of the other set of dates, depending on how the prosecution will cross-examine.
I don't know how hard the first accused, because the record shows, and my correction also confirms, that utilized by the defense of the first accused and his 2 witnesses, but that did not.
Good morning, my lady. First, mine were issued the next month because I was very sure I may not be here. But I took them on condition that they would be utilized by my colleagues. Virtual.
Defense counsels had an issue with availability
Yes.
of the candidates, but we indicated that we just fixed them in the event that in order to accommodate, but that did not mean that there were dates only reserved for the evidence of the first accused. That's the point I'm making.
Very true, my lady.
That's the point I'm making. That there were days set for defense here.
True, my lady.
For all the accused persons. But obviously, with the knowledge.
My senior indicated the number of witnesses he had, and subconsciously, we thought they would utilize. We saw the first witness actually took the first day and slipped over to the second. So had they brought the number of witnesses they indicated they would, 3 days. But we apologize to the court. I am sure the next set of days will accommodate both myself and Mr. Ogada, given the nature of evidence. Actually, I've noticed we may share some witnesses with him.
and so the time will be sufficient.
I give my directions, then you also hear the other council with regard to Mr. Obado's request.
We're looking for our site.
Mr. Jason.
That application for adjournment for two reasons, my lady. One, obviously the record bears as witness this case has taken so long. And the family of the victim would really wish to have a closure to this matter at the earliest. Secondly, my lady, as already correctly noted by the court, these dates were taken by consent of all the parties. They were dates taken for defense hearing. Well, it's appreciated that other witnesses for the second accused may not be in court, but at least the second accused himself is in court. I do not think any plausible reason has been given as to why the second accused cannot open his defense case right away. We have the rest of the day today and the rest of tomorrow, the whole day tomorrow. No reason, my lady, in our view has been given sufficiently not to utilize today and tomorrow.
For adjournment by Landed Council Mr. Meso, as well as the submissions made by the other defense councils, as well as Landed Prosecution Council and Council for the victim's family, and also having perused the court record. I note that these 3 days had been set for defense hearing, and although there appears to have been some misunderstanding regarding the expectation of how these 3 days would be utilized, it is understandable then that the second accused person may not have produced his witnesses today, and he will need time to probably also prepare for his evidence. It is, however, noted that it is still early in the day, and nothing, there is no reason why the second accused should not utilize the time remaining today, so that he prepares for his evidence, so that his evidence is he's able to open his case from tomorrow, and he can avail the rest of his witnesses on the 3 days that are slated for hearing in the month of May. So in the circumstances, I will allow the adjournment for today, so that the accused number 2 can utilize the time between now and tomorrow to prepare for his case, so that we resume tomorrow to start with his case.
plead with you to accommodate us. We come when we are sufficiently prepared and with the correct mental state to start in May. But then she had also hoped that I would stand in for her in tackling the first accused witnesses tomorrow. She was aware of the exam dates. I can't say she didn't know, she was aware. But she had hoped that I will stand in for her tomorrow. And unfortunately, my lady, this is not something I need to tell the court. I've had a sick child for a while now. And the mother is scheduled for surgery in one of the local hospitals, my lady, and have to be there.
Wishes to be present on that account. I would be gracious to allow to not to object for personal.
Sorry, Mr.
I'm
Award.
just now saying that I'm now withdrawing my objection for tomorrow based on what the council has said. That what he has said was not known to all of us
Yes.
at the time.
Yes. Information regarding your unavailability tomorrow when you were addressing the court on your application for adjournment. This is coming, and the reasons that have been cited, which are compelling, given that it involves a sick child who is scheduled to undergo surgery tomorrow. So despite the fact that this is a long time that needs to be expedited, and the fact that we still had time today and tomorrow to utilize for the defense hearing, for those particular reasons, I am prepared to review my decision and allow an adjournment to the date set in May. That will be the 19th to the 23rd of May 2025, when the accused 2 and accused number 3 will be expected to proceed with their respective defense cases. So I hope that you will come prepared together with your witnesses so that we make progress. That is the only reason I have reviewed my decision.
We are gracious, ma'am.
Not because of anything else. But next time, make sure that you place other reasons to necessitate a review of the decision that the court would have made.
Much better.
Yes. Until the 19th.